and 85. Now here's your host, Attorney Jeff Vastola.
Well, good morning, everybody, and thank you once again for tuning into Vastola on the Law. I am Jeff Vastola, your host. I'm here just about every Saturday morning live to give you free legal advice, and that's exactly what I'm going to do here today. My board operator, Sharina, is a little bit late, and I'm on autopilot at the station, which is why you're hearing some feedback that ordinarily we wouldn't hear. I'm going to try to minimize that noise for now. Hopefully when Sharina arrives, she can fix that for me. But if you'd like to call into the show because you're listening to the radio, the number is 877-850-8585. If you are watching on Facebook Live, as I'm seeing people watching, Moses, good morning, then type in a question if you have one, and I'll be happy to get to your question as soon as I can. If I can answer it right here and right now, whether it's on the radio or Facebook Live, then I will give you my answer. If I have to research the issue, then that's exactly what I'll do, and I'll get back to you the following week. If you were listening last week or watching last week, you heard Mark call in with a question about cremated remains and a very confusing family tree of who's entitled to them. Well, I did the research, and so that's my topic for the day. I'll be talking about who has the right to cremated remains in the state of Florida. Now, keep in mind, I'm only licensed to give legal advice in the state of Florida. So if you're watching on Facebook Live from some other state, then if you have the same question, you may get the wrong answer because states' laws can differ on some things, especially the rights to cremated remains. That's certainly a law that could be different from state to state. So I'm going to be talking about that. That's going to be my main topic. I'm going to be talking about some of the additional benefits of coverage. Most people are aware that they can opt for uninsured motorist coverage on an automobile policy, but oftentimes they don't know all the reasons why they might want to do it. So I'm going to be talking about that, but let me get some preliminary stuff out of the way. First of all, we are now down in the Keys as of April 1, which is not here yet, but we're working towards it. On April 1, we are actually going to have an office down in Tavernier, which is the key in between Key Largo and Isla Mirada. And so if you know of anybody down there that needs an attorney, have them contact me. And of course, my toll-free number that goes to my cell phone all the time is, Uncle Jeff, good morning, 833-VASTOLA. That's a number that you can reach me 24/7. And then I believe I owe a phone call to Diane. If Diane, you're listening, I will get back to you. I have a voicemail in my phone from you. But 833-827-8652, that's a number that you can call anytime, 24/7. And leave me a message if I don't answer, and I will get back to you. And if you want to talk to me about a potential case, that's a great number to use because you can use it on the weekend, you can use it at night, whatever you like to do. But we are down in the Keys. We have procured the domain name injuredinthekeys.com, so we're going to be trying to do all the magic that you do with Google to make sure that that's working. But if you go to injuredinthekeys.com right now, you will see that magically my website pops up. So anyway, moving on, we are putting on our very first Vastola free legal seminar. I've done a seminar like this once before in my life. It was a very, very long time ago when I was active with a television station. And we actually did the seminar there at the television station, which was very convenient. This time around, I'm promoting it on my own via Facebook, the radio, and whatever else there is to do. But April 27th at the Embassy Suites in Palm Beach Gardens, we're putting on our very first free legal seminar. And it's not just legal. It's going to be free information. Most of it is legal. But it's going to be free information about insurance, not just automobile, but all different types of insurance. And I'm planning to have a health professional there to talk about how to stay healthy, how to stay fit, and a panel, if you will, of different types of attorneys that practice different areas of law, so that if you're there and if you have a wills and trusts question, which of course I can never answer those, there will be somebody there that will dedicate some time to give you some free advice. So that's what we're going to do. We're going to be socially distanced. We'll be whatever the protocol is at the time for the state of Florida, masks, we'll be doing it. So we hope to have you there April 27th from 1 to 4 at the Embassy Suites in Palm Beach Gardens. It's a very first Vastola free legal seminar, and we hope to see you. But there's going to be raffle prizes. We're going to have one of which is a set of tires to somebody that is hopefully in need of tires, because that's a big issue for me. And we would ask that if you're planning to come, go to my website and RSVP, just so that we can try to get a head count. We've got a pretty decent sized seminar room at the Embassy Suites, but we do like to know, if we can, how many people are going to be in attendance. Shrina, are you with me yet? I got a message that Shrina was going to be showing up late today. She is my board operator. I am no longer hearing my voice in the background of the radio show, so I'm hoping that that means it's working. Shrina, are you there? Well,
no, actually, she's not here yet.
Okay, all right. Well, when the show started, I was getting some reverb, so it seems like you fixed it.
Yeah, that was my fault. I'm sorry.
No, you're fine. You're fine. It's all good. All right. So let's jump into our first topic of the day. Again, if you want to call into the radio show because you're listening and you have a question of your own, dial 877-850-8585. That's the number to call into the show every Saturday morning from 7:30 to 8. Just put that number by your phone, and that way you can call into the show. You will be live with me, and you can ask me anything you want. If I answer your question here and now, well, there you go. If I need time to research it, then I'll take that following week. And if you happen to miss the follow-up show, you can always go to the library and find it. The library, you may ask, where's the library? Well, the shows are uploaded to my website. The shows are uploaded to my YouTube channel, which I don't promote very often, but I have a YouTube channel, and the shows are there. And you can also go to the radio station's website, which is 850 AM, and you'll find it's kind of hard. Their menu is not the most user-friendly, but you can find my show Saturday morning, 7:30, and I have a show page, and then within my show page you can find the show there too. So it's in a lot of different places. If you miss a show, you can go back and listen. So, last week, if you were not listening, if you were not watching, Mark called in with a question, and a very convoluted family tree to try to figure out exactly what's going on. But regrettably, his nephew died in a motorcycle accident, and apparently, his nephew's relationship with his mother was very strained. So much so that Mark's mother, who is the nephew's grandmother, legally adopted him. From what I'm gleaning from the conversation is that the mother is the one that would have the rights, pursuant to the Florida statute, to the cremated remains of Mark's nephew. I didn't get the boy's name, so I'll just keep referring to him as the nephew or the decedent, the boy that died on the motorcycle. So Mark's question was, okay, well, somehow, some way, the decedent's mother came into possession of the ashes, and she doesn't want to give them up, the cremated remains of her son, which makes sense. I can understand why a mother would want her son's cremated remains. But the grandmother had legally adopted the son, and so the question is, well, the grandmother wants the remains too, and the daughter won't give them up. So wherein lies the answer? Well, not surprisingly, the issue has actually come up in the past. You may say to yourself, wow, that's a first. Well, no, it's not. There are a few cases dealing with the cremated remains of somebody that's passed on and who has the right to keep the remains. Now, I'll tell you right now, what most courts have done is they've adopted Solomon's approach. You know, Solomon and the baby, if you've ever heard of that. Two women, obviously back in biblical times when Solomon was a king, approached and were disputing who was the actual mother of the baby, and Solomon said, okay, let's split the baby. And of course, the true mother of the baby said, no, let the other woman have it, and that allowed Solomon to determine who was the true mother. Well, in cases like this, where people are feuding over who has the right to cremated remains of a decedent, of a loved one, oftentimes the courts literally say, split the remains. And it seems like a pretty equitable way to do it. But there are some cases that have said you can't split the remains if, number one, if there's testamentary intent for a specific person to have the remains, then that's what's going to govern. And if you're not sure what I'm talking about, it's what's written in a will. So if you have a will, and if you haven't designated in your will who is supposed to have possession of your remains, please fix your will so that people that you leave behind don't end up in court fighting over who's supposed to have your remains. But secondly, in the absence of testamentary intent, then the law in Florida says whoever has the legal right to the remains can decide how they're supposed to be split up. Now, I would think in most situations, I don't want to call it common sense, but love would prevail, and the remains could be split if you have several different people who want to share them. I'll just tell you, speaking for us, good morning, my beautiful mother up in Tennessee. When my father passed away, he was cremated, and this is an issue that's still very raw. My father passed away on December 27th from COVID, and he was cremated. And what my stepmother was doing, who obviously had the rights to those remains and everything else, is that she asked all of my father's kids. My dad had 5 kids. And she asked all of us, do any of you want some of the remains? Because what funeral homes will do when a decedent is cremated is they will give you all kinds of neat little keepsakes if you want. You don't have to. And so I and a few of my siblings opted to have a portion of my father's remains in a neat little keepsake thing, and I actually keep mine on my bathroom counter. But so I think more often than not, the division of remains is handled amicably. But in those cases where it's not, I've found in Florida's case law and then in the statute what the answer is. And it says, I'm just going to cite from a case called Kirksey versus Jernigan. If we have any scholars out there, it's spelled Kirksey v. Jernigan, Jernigan, and the citation is 45 Southern 2nd 188. This is a Florida Supreme Court case from 1950. It says, in addition to these statutory provisions, and what happened is there's a very lengthy opinion where the Florida Supreme Court delineated a bunch of different statutes that apply to a death and disposition of a body and stuff like that. Not all of them are applicable to cremation. But it says Florida case law has long recognized the right to possess a loved one's remains for purposes of burial or other appropriate disposition. It is well settled that in the absence of testamentary disposition to the contrary, that's what I was talking about before, where if you have a will that says, if I die, my wife has the right to my remains. Well, there you go. Question answered. There's no one can contest that. A court can't interrupt that at all. But it says in the absence of that, a surviving spouse or next of kin has the right to the possession of the body of a deceased person for the purpose of burial, sepulture, or other lawful disposition which they may see fit. And the invasion of such right by unlawfully withholding the body from the relative entitled thereto is an actionable wrong for which substantial damages may be recovered. So it's talking about, in this case, sometimes where the state may hold on to the body of a decedent and withhold it from the family and things like that. But it also goes on to cite many cases where they're talking about the cremated ashes of the decedent and who has the right to them. So this case, although Mark, I don't think intentionally drafted his own Florida bar exam question for me to deal with here, but it's very much like a Florida bar exam question because there's all kinds of twists and turns. He mentioned right off the bat that the grandmother had adopted her grandson. And so without getting into personal issues, you realize, okay, there must be a reason for that. And what comes along with adoption are legal rights. Not only do you have legal responsibilities when you adopt a child, but you also have legal rights. And so we don't know whether the mother voluntarily gave up her rights, but what we know is the grandmother adopted the son. And if that was a legitimate, valid adoption in the state of Florida, then she is considered next of kin who has the right to these cremated remains. Now, the case law, which are cases that have gone ahead and they've resulted in written opinions from appellate courts, says that when loved ones are fighting over the remains of someone that's been cremated, they leave it to the discretion of the trial court, which is the judge sitting at the trial level, to determine what is the best remedy given the situation. So even though the Florida statute tells us who has the right to it, and there's Florida Supreme Court case law, which we call stare decisis, it's also referred to as jurisprudence, we have that case law giving us guidance. Sometimes the trial courts can say, given these facts are so compelling to me, I'm going to make a decision that's contrary to what's already there. And sometimes the courts are allowed to do that. They can distinguish their facts in front of them from what's gone ahead of them. So there is some suggestion in these opinions that it's a case-by-case basis. But let me read to you the conclusion. It says, based upon these statutory rights of the next of kin and their dead relatives' bodies, along with the case law on this issue, we conclude that in Florida there is a legitimate claim of entitlement by the next of kin to possession of the remains of a decedent for burial or other lawful disposition. We also find that referring to interest as a legitimate claim of entitlement most accurately describes the nature of the interest. And the reason why they made that
Mark from Boca
reference at the end is because, hang on just a second, is because all of these cases make very clear that the right to a dead body or ashes are not property, because there's all kinds of statutes that deal with the property of a decedent. They want to make sure that the body is not considered property. Okay, so let's talk to Mark in Boca. Good morning, Mark.
Call drop, never mind.
Okay. Hi, Sharina. How are you?
I'm good. How are you?
Good. Okay, so I'm going to move on then from what I called the stare decisis, which is this Florida Supreme Court case, and I'm going to talk about the actual statute now. For any scholars that are interested, you can find the statute dealing with cremation at Florida Statute 497.601. That's where it starts. It's entitled Part 6. So there are 5 preceding parts to this particular statute, but this is Part 6. It's entitled Cremation, Crematories, and Direct Disposition. And it's 497.601 through 497.609. And I'm going to scroll down to 609 because that's where I found what I thought was the most interesting bit of language. And I'm sorry, it's a lengthy statute, so I'm scrolling. Okay, and here it is. So in 497.607, subsection 2, it says, I just alluded to this a moment ago, cremated remains are not property, as defined in Florida Statute 731.201, and are not subject to partition for purposes of distribution under Florida Statute 733.814. A division of cremated remains requires the consent of the legally authorized person who approved the cremation, or if the legally authorized person is the decedent, the next legally authorized person pursuant to 497.005. A dispute regarding the division of cremated remains shall be resolved by a court of competent jurisdiction. So a court of competent jurisdiction simply means that you're in the right courthouse. That's essentially what that means. And so what's interesting is that this statute is basically saying it's up to the trial judge. Now, the attorneys who are going to be presenting the case to the judge are there for a reason. I mean, there are reasons that people make that cliche comment all the time about, the person that represents himself as a fool for a client, and so on and so forth. Lawyers are there for a reason. Good lawyers would research the issue, know the case law, know the statutes, and present a compelling argument to the trial judge as to why, yes, indeed, the statute says that, Judge, this is completely up to you if you read it that way, but really it's not, because look at all the case law that's come before that suggests you first have to look to the will, and secondly, if there's no reference in the will, then I would suggest that I don't know this for sure, but I'm guessing that most templated wills probably don't make any reference to cremated remains. So again, if you have a will, and if it's important to you, make sure it's clear in there, because you may say, well, I have a will and all my property is clearly, designated to go to this person. Well, what I'm showing you is that the Florida courts have gone out of their way, and the Florida legislature have gone out of their way to say that cremated remains are not property. So you can't distribute your remains just because you've said, okay, I want my car to go to this person, I want my money to go to my kids, I want this and that. It has to be handled separately. So if it's not in your will, change it or amend it. Do a codicil, I think is what they call it. And if you have any questions, call me. You can call me anytime at 833-VASTOLA. That's 833-827-8652. That's a number that goes to my cell phone, always. Not just on the weekend, but always. That goes to my cell phone. And so you can call me with any questions that you may have. If you ask me a question I don't know the answer, I'm going to do the research and get back to you. Mark's question started out last week as, it's a very sad issue. Obviously, his nephew passed away in a tragic accident, and there's nothing entertaining about that. But the nature of the question and the content of the answer became very interesting the more I researched, and that happens all the time. So I really do encourage people to call me with questions where I don't know the answer, because that forces me to then do the research, and that's what I really enjoy. So if you want to call into the show, I believe we lost Mark. Mark, if you want to try again, it's 877-850-8585. I am Jeff Vastola, your host of Vastola on the Law. That's what you've been listening to or watching by Facebook Live. Oh, great. Let's talk to Mark. Good morning. Hey, Mark. Mark, I need you to turn down your radio, my friend. Mark, are you with us?
Hello?
Mark, turn down your radio, please.
Hey, Jeff. How are you?
Good. How are you doing?
I'm having a problem hearing you. I don't know why. Can you hear me okay?
I can hear you fine. You just have to turn down your radio.
No, my radio's not on at all. I'm just on my way to work, but I really appreciate that you are looking for that person.
So, let me just make certain that I got the facts right. You told me that your grandmother adopted your nephew. Is that right?
My brother was a sole parent. He was a single father, and my brother passed away. And when my brother passed away, my mother, Tyler's grandmother, adopted him.
I see. Okay, so I had factually the family history incorrect, because the sister is not the mom. Is that right?
No, that's the daughter that has the ashes is my daughter.
Is your daughter. See, okay, my apologies.
Since the accident, there's been tension in the family. So my mom was, like I said earlier, my mom was living with her. When my mom moved in with me, my daughter refused to give her to the ashes of Tyler, because my mom had the possession of the ashes when she was living with my daughter. Yeah. And when she left, my daughter hid the ashes on her and said she wasn't going to give them back to her. She wanted to hold them.
Well, in this situation, it seems pretty clear to me. I can't give you a guarantee, but it's pretty close to one, that if your grandmother legally adopted your nephew, because of the situation at the time where his father had passed away, she has those rights to possession of the remains. So she should probably retain a lawyer. Obviously, try to work it out in advance. Don't just run to the courthouse. But your daughter should be made aware of the fact that she has no rights to the remains, and if she doesn't hand them over, then a lawsuit's going to be filed, and the court's going to make her do it.
Okay, I'm having a very hard time hearing you. I heard what you said. It's breaking up a little bit. But again, I did listen to your researching and your case law, and I appreciate it so much.
Yeah, and another recommendation.
It's a great help.
Yeah, well, no problem. That's why I'm here. Another recommendation would be that maybe they could split up the remains if it's really that important to both of them.
We've tried. She won't release them.
Yeah. Well, so, she doesn't.
It's a horrible feeling. You have to take a relative, especially a daughter, and a whole family issue like this over some remains instead of doing it, just being civilized about it. She's rough, my daughter, and she refuses.
Okay.
So that's what I'm in the midst of doing right now. When I called you last week, I was in the middle of going down to the clerk and doing all the paperwork. But I was curious, and I listen to your show every week on the way to work, and I figured I'd give you a call, and I'm glad I did. You answered all my questions.
So am I. Thanks for calling, Mark. It was a really interesting issue for me, and hopefully somebody got something out of it in addition to you.
I hope so. I hope it happens, and I hope it doesn't happen to anybody else.
Well,
yeah, thanks a lot.
You're welcome. You're welcome, Mark. Safe travels on your way to work this morning. And that's the point. You know, that's the point here is that if it's not in your will, put it in your will. That way the people that you leave behind don't have to toil with this kind of stuff. So
1 minute.
Yep, I was going to say I'm about out of time here. So thank you so much for tuning in, whether it's by the radio or Facebook Live. I really appreciate the interaction with the audience. Remember, you can call me at 833-VASTOLA anytime, weekend, at night, I don't care. If I can answer my phone, I will. If I do not, leave me a voicemail message and I will get back to you. As I mentioned, Diane, I believe your name is. I owe you a call. And remember, we have an office in the Keys as of April 1, injuredinthekeys.com.
37.
And our free legal seminar coming up on April 27th from 1 to 4 in Palm Beach Gardens at the Embassy Suites. Please make sure that you attend and give us an RSVP. I'm Jeff Vastola saying thank you very much. Have a great week and God bless.